Ready, start. The interchange fee is the consideration that accrues to the issuing bank for verification, facilitation, and extending the purchase value in line with the contractual agreement, the issuing bank has with the card association, and also for taking the risk of collection from the cardholder. Full stop. Interchange fee is, according to the appellant, consideration received as a result of contractual agreements with the card association to facilitate purchase of goods or services. Full stop. The contention of the respondent that the activity is to be treated as a transaction in money, is disputed. Full stop. The issuing bank is debited the purchase amount less interchange fee. Full stop. The interchange fee is the service charge for allowing the transaction. Full stop. The debited amount is a transaction in money. Full stop. The service charge is demanded only on the interchange fee and not on the purchase amount. Full stop. The complaint of the respondent that there is double taxation, is disputed. Full stop. This happens only after receiving the amount from the issuing bank, which is net of interchange fee. Full stop. The interchange fee is the consideration given to the issuing bank for validating the e-transaction, whereas MDR is the consideration for the acquiring bank for settling the merchant establishment. Full stop. MDR is fixed as the percentage of sale cost or service cost, whereas interchange fee is fixed by the card association, taking into account other aspects dash the cost of moving money, the time value of money in terms of current interest rates and the relative risks involved, etc. Full stop. They are two independent transactions. Full stop. There are also two separate services forming part of credit card service. Full stop. No service tax has been paid by the respondent on the amount received as interchange service towards rendering taxable service. Full stop. The fact of payment of service tax by acquiring bank does not absolve the issuing bank from payment of tax on the consideration received by it. Full stop. There is no double taxation. Full stop. It is also contended that without prejudice to the said contention, the respondent has not produced evidence to establish payment of tax by the acquiring bank on the interchange fee. Full stop. It is also contended that the extended period of limitation has been rightly invoked in respect of the SCN dated 24/3/2013. Full stop. There was no basis for the respondent to form a bona fide belief that their activities are not liable to service tax. Full stop. There was no order of the tribunal which could have persuaded the respondent to think that it was not liable to pay tax. Full stop. The definition is unambiguous. Full stop. No clarification was sought from the department. Full stop. Under the regime of self-assessment, the onus is only on the assessee to assess the tax liability honestly and as per law. Full stop. It was only due to the verification of the accounts during audit, that the evasion by the respondent, came to light. Full stop. During the investigation also, it was contended by the respondent that the service tax had been discharged by the acquiring bank, but they did not submit any proof. Full stop. The present was, therefore, a case of fraud, willful misstatement and suppression. Full stop. It is further contended that the appeals are also not maintainable for the reason that the commissioner had deviated from the show cause notices and arrived at findings on matters which were contrary to the case set up in the show cause notice. Full stop. It goes to two aspects. Full stop. In the show cause notice, it is stated, as already noticed, that even if the acquiring bank has paid tax, that would not absolve the respondent from its liability to pay tax. Full stop. In other words, show cause notice is based on acceptance of payment of service tax on the entire MDR, which includes the interchange fee. Full stop.